The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Good morning, everybody. Please be seated. Welcome to the United States Court of Appeals for the Fourth Circuit. We have 4 cases on for hearing this morning. First is 22-4384, United States versus Shade. Mr. Kilbourn.
Chief Judge, judges, may it please the court. I am James Kilbourn, and it's my honor to represent Kewan Shade under the Criminal Justice Act in this appeal. The court below described the defendant's arguments as a, quote, saved by the unicorn argument with very, very technical points. As a defendant's appellate counsel, we're always looking for those very technical unicorn issues because our clients are overwhelmingly charged with federal crimes, are convicted, and the overwhelming majority of those convicted have their convictions and sentences affirmed. So we're like prospectors looking for gold nuggets, trying to bring them to the court's attention. In this case, Your Honors, I believe we do have an interesting issue that deserves your attention and deserves.
So were you counsel below?
Yes, I was actually, Your Honor.
All right.
So I was the unicorn trainer below. Yes, sir, Your Honor. In this particular case, I believe we have a situation where North Carolina's assault with a deadly weapon with intent to kill is not a crime of violence. And we believe that that's the case because of the unique nature of the definition under the guidelines of what is a crime of violence and its requirement to communicate a threat and the receipt of a threat. That we need both the transmission and reception of a threat.
Well, you would have a very difficult time convincing most people that assault with a deadly weapon with intent to kill was not a crime of violence.
I realize it's not intuitive, Your Honor, and I'm not saying it's not a violent crime. What I'm saying is under the guidelines, a particular crime of violence requires a particular set of circumstances. And that particular set of circumstances under the categorical approach is the attempted use or the threatened use of force.
I don't want to totally distract you from this argument, but it seems like your response to Judge Agee sort of concedes the harmless error point, right? Because the district judge here says, listen, you might find some technical line here, but like we sentence based on facts. And as you aptly said, we can rearrange the deck chairs on the Titanic as much as we'd like, but fundamentally, right, the question here is like, did the court reasonably sentence him, and would he have sentenced him the same way regardless of this crime of violence issue? And your response to Judge Agee says, yeah, this is a violent crime. Yes, it's really bad. And that leads me to think, like, a reasonable judge could say, even if it doesn't meet the technical definition, I should sentence him as if it did.
Well,
and that seems like what the district court did here.
Right, and I have no doubt that's what the district court did because the district court said that was what they were doing. And I appreciated your comments yesterday, and I agree with you that being a district court judge is a very, very hard job.
And we're, and I guess what I'm trying to understand is, so I at least understand theoretically your technical arguments, but if you're right about those, doesn't that just lead you straight into harmless error? That, the district court was pretty clear here that if you found this like unicorn rainbow theory, it didn't change the facts. And the facts here is that your client was a violent criminal.
So, and I believe that that's why the judge says this, is so that the harmless error issue is raised. I would argue that there is a procedural process that sentencing is required post-Booker, that we must correctly determine the guideline sentence, and that guideline sentence is not mandatory, but it at least has to be relevant. And I would argue that saying that,
Well, why does it have to be relevant? I thought the court said it has to be considered, right? But here the court seems to say, I looked at it, right? The real answer to me is I've considered it, and I find it irrelevant. Because at the end of the day, your guy is a violent bad guy, and whether it meets some esoteric definition that nobody frankly understands, like, doesn't affect my fundamental, like, discretion in deciding what his sentence is.
I would argue that the discretion has to be exercised off the basis of a correct guidelines determination.
Well, but the court didn't seem to say that, right? It says the guidelines have to be considered, but the very nature of them being non-binding means they can't, like, tie his hands in any way, right? Like, they're not binding. Otherwise, Booker doesn't have force.
Well, it does in some way change the relevance of the review by this court if something is twice the guidelines or half the guidelines. Now, that being said, you make...
That may or may not make sense, and I understand that we've said that, but
Right.
my point is if they're not binding, if Booker means what it says, then, like, they're one thing to consider, just like his childhood or the nature of the crime or anything else. But a reasonable district court could say, the guidelines don't make sense in this context, right? The rainbows and unicorns don't matter to me here, and so I'm going to ignore them completely, it seems like to me.
Well, but I think Gall says you can't ignore them completely.
No, it just says you have to
go-
consider them,
Well,
right? You have to
go
consider them.
You have to go through the process and correctly determine them. Now, he can say whether I correctly determined them or not, here's what my result would be, but that cuts out the first step of the process. And the first step of the process is this a defendant with a 14 or is this a defendant with a 20?
So
Now,
the chairs on the deck of the Titanic must be in the right spot, even though we all know that it's going down.
this is a criminal prosecution. I would argue yes. I would argue, again, it's a hard job. And I am technically nitpicking an issue that I think is very important in his particular case as to whether or not he walks in front of the judge with a 20 guideline as the judge determined, or with a 14 or 12 guideline as I would suggest is appropriate. Now, they have, the Congress and Congress and the Sentencing Commission have defined what the guidelines are regarding a crime of violence. As we've seen, if they don't like your interpretation of those guidelines, they can change them, and they have. In this particular case, you understand the argument that it has to have a threat that is both given and received. And under North Carolina law...
What's the, I'm sorry, Mr. Kilborn.
Sure.
What's the support for that combination of both given and received?
That would be Taylor, Your Honor, that we argue that Taylor, examining the kidnapping statute, said that a threat of force must be communicated. That, in other words, it can't just be a generalized threat, that it
Well,
must be
communication
individually
doesn't-
communicated.
Well, I mean, so you're suggesting that communication is a two-way street in every instance?
I believe in every instance it would
Is that
necessarily
what
be
the Supreme Court said?
I would argue that in Taylor they did, that a generalized threat
Or were they
that's not
using
understood.
communication in a more generic sense with no indication that it was meant to apply in this context?
I obviously am using communication in a particular sense, Your Honor, but I believe that's the sense that was intended in Taylor, that the threat was both given and received, and just giving threats is not a threatened use of force.
Well, why don't you tell us specifically why you would, moving away from harmless error for a moment, why you would say this is not a crime of violence?
Well, here's the argument, as it was made below and as I've made it to in the briefing, is that the categorical approach requires the use, attempted use, or threatened use of force. And a threat of force, we would argue under Taylor, must be communicated from the defendant committing the act to some second party who receives that threat. In other words, shouting to yourself is not really a threat if no one hears it. It needs a transmission and a receipt of a particular threat.
So are you challenging the mens rea requirement here? I thought that was part of your argument.
No, I believe they have the best of the mens rea question on recklessness. But what we are saying is that under a categorical approach, the North Carolina assault statute requiring an unequivocal appearance of an attempt with force or violence doesn't actually have to be communicated. In fact, in Musselwhite and Starr, it says that it's not necessary that the victim themselves be placed in fear in order to sustain a conviction for assault. In other words, there has to be a communication forward of a threat, but there does not have to be the receipt of a threat. And I would argue that's where the federal law regarding communicating a threat as part of the threatened use of force differs from the North Carolina definition of what actually is an assault with a deadly weapon with intent to kill in this particular case. And North Carolina law says that no one has to know of the threat or violence for a conviction. I would argue that based upon Taylor and based upon the reading of the guidelines, the threatened use of force requires both.
So let's look at a hypothetical. Let's
Sure.
say the person we'll call a victim is looking one way, the assailant comes up behind him with an axe, takes a swing, but he misses.
Right.
And so the purported victim never sees it. 10 other people standing around there do see it. Is the threat communicated in that circumstance?
It's communicated to the third party who saw it. Now, the
That's
tougher
sufficient.
question, obviously, is if no one's there to see the tree fall in the forest, if no one's there to see the swing of the axe, is that actually a communicated threat? And I would
So
argue,
let's say we caught it on video.
again,
Not communicated to a person, but it's on the video. Is that sufficient?
someone's seen the video, so it's then communicated to a person. I would argue that it's both the transmittal and the receipt of a threat that leads to a threatened use of force. That if you threaten to use force and no one knows about
Isn't that
it,
circular? Because if, in your you're saying the only instances where nobody ever knows about it, but somebody is always going to know about it, otherwise it's not being prosecuted, right? So somebody has to have seen a video or observed it or something, otherwise it's not prosecuted. I mean, this seems like a fanciful hypothetical, right? The like axe swing in the forest that nobody sees. Like, how could that ever be an actual case? If your theory is right, that just seeing it on video or some third party can be the one that receives the communication, it doesn't have to be received by the victim, him or herself.
well, the hypothetical I gave you in the briefing that I've stuck to is this idea of it being perceived by the defendant as a threat, but not being perceived by the victim as a threat because they have some specialized knowledge that lets them know that they aren't threatened with that violence. That to me would qualify as an assault under North Carolina law, but it would not qualify as a communicated threatened use of force under the federal crime of
Well,
violence
he
statute.
communicated the threat, right? I give you the note and say, I'm going to shoot you, or I guess in your example, he just says it.
Yeah.
Right? He has communicated a threat. Like, the victim happens to be unusually hardy, right? Or unusually, like, thoughtful or smart or knowledgeable. But that doesn't interfere with the communication of a threat.
I would argue it interferes with the receipt of the threat, that there actually is not under federal law an actual threatened use of force if the other party does not correctly perceives that it is not actually a use of force under the circumstances. Now, again, I call these gold nuggets on purpose. I mean, this is not something that you'll encounter every day, but our argument is that it is not a clear categorical match because of North Carolina's determination that there is not a requirement that the victim be placed in fear to have an assault.
So under Judge Agee's hypothetical, putting aside the existence of a video or
Right.
bystanders, swing at a victim with an axe, you don't think North Carolina would prosecute that as an assault with a deadly weapon with intent to kill?
I believe that they could because that threat in North Carolina does not have to be communicated. So if he came to the office and confessed and said, I swung an axe, that would be a communicated threat in North Carolina. Or in North Carolina, it would be the unequivocal appearance or an attempt with force or violence to do some immediate harm. It would qualify under North Carolina statute. I would argue that it is not a communicated threatened use of force under the guidelines. And that's the subtle difference, I believe, that makes this not a categorical match.
Okay, thank you, Mr. Kilborn.
Thank you. The other issue, obviously, we have is, one of the other issues that.
We only have about 15 seconds.
I know I only have about 50 seconds. One of the other issues I think is that there was not actually a substantial risk or death or serious bodily injury during his escape. And I don't believe there's any case that has been brought forward with a set of facts with a set of facts as less serious as ours, where there has been a find of a force, but I'm sure I'll have a chance to talk to you all about that in a minute. Thank you.
Ms. Reed?
Good morning. May it please the court, Mahogany Reed for the United States. I'll start with Mr. Shade's challenge to the calculation of his base offense level under 4B1.2. I understood Mr. Kilbourn this morning to concede that assault with a deadly weapon with intent to kill carries the required mens rea element to satisfy the use of force under the elements clause in 4B1.2A1. The only question raised today is whether assault with a deadly weapon with intent to kill requires a communicated threat, and to what extent Taylor suggests that a victim is required to receive a threat. And I don't read Taylor to suggest that assault under North Carolina law requires that a victim personally perceive fear or receive fear based on the defendant's actions. I read Taylor to disclaim any suggestion that a communicated threat or a threat of force can be sort of abstract and objective in the way that the government argued in that case.
Are you aware of any North Carolina state court case that suggests that it has to be a two-way line of?
I'm not aware of any North Carolina state court case that suggests that it has to be a two-way line, but assault under North Carolina law does require that the defendant's actions convey or communicate a threat. I understand Mr. Kilbourn to focus on the part of the definition of attempted battery assault that requires the unequivocal appearance of an attempt to commit an assault. But the sort of second part of that definition of assault says that the unequivocal appearance of an attempt has to place a reasonable person of reasonable firmness in apprehension of fear or harm, and we think that that satisfies the communication requirement to qualify as a threat of force under 4B1.2.
But how is that the case if the recipient never understands the threat to be existing?
Yeah, I don't think that that is required, right? The question is whether the defendant's actions convey a threat necessarily, such that a reasonable person who does perceive the defendant's action would be placed in a reasonable fear of harm. And so,
Even if under the facts of the case, as Mr. Kilbourn would have it, that person never perceives it, it's just the objective. We're looking at this objectively, is that your point?
Yeah, I think so. I mean, I think it's important to distinguish between what I understood, at least before this morning, Mr. Kilbourn to be arguing, which is that the victim themselves in every single case has to be placed in fear, not necessarily that they have to sort of perceive the defendant's actions and not be placed in fear, which I think would be enough to satisfy the communicated threat, right? It would be conveyed, the defendant's threat would be conveyed to the victim, and whether the victim is actually placed in fear is irrelevant to the question, because the defendant's actions were sufficient to place the victim or a reasonable person in the victim's shoes in fear of risk or bodily harm. But we don't read Taylor to require that a victim actually experience the feeling of fear based on the defendant's actions. That's just not what Taylor says.
Can I ask the follow-up question? The hypothetical, I think we're addressing two hypotheticals. One is they know the firing pin is out of the gun or whatever, that hypothetical. But we also asked the swing the axe in the woods that nobody sees hypothetical. I wonder, would that satisfy the North Carolina requirement that there's an unequivocal appearance of an attempt? Right? It seems like in that hypothetical, that one doesn't get us anywhere because the victim or nobody perceived any attempt. There was no appearance of an attempt. absent a video or a third party, and so there would be no appearance in that case. So that hypothetical wouldn't satisfy under North Carolina. And so we're back to this hypothetical where we have a victim of unusual hardiness who is not scared.
Yeah, I do question whether the hypothetical where the defendant swings the act that no one sees would be prosecuted as an assault under North Carolina law. I did some surveying of North Carolina law, and I couldn't find a hypothetical or a case that sort of presents a similar set of facts where a defendant takes actions that literally nobody sees, or maybe that's caught by a third, electronic device or something that someone sees later, but that is prosecuted as an assault under North Carolina law. I just haven't found that case.
Both because there's not an appearance, but also in your mind, that wouldn't be placing a reasonable person in fear because they didn't perceive anything.
That's right, Your Honor. That's right, Judge Richardson. Now, with respect to Mr. Shade's proffered hypothetical of pulling the firing pin out of a firearm and pointing it at the individual who actually pulled the fire pin out of the firearm and acknowledge or recognize that the firearm was disabled, I think that would qualify as an unequivocal attempt to commit an assault on behalf of the defendant, but as we explained in our brief, it would not satisfy the rest of the requirements under the assault, in that it would communicate to a person of reasonable firmness in knowing everything that the victim knows, and in this case, the victim knows that there's no firing pin in the firearm. It wouldn't place that person in fear of death or serious bodily injury.
Back to the hypothetical of the axe in the woods, which seems to be getting quite a lot of time this morning. Is there any crime that hypothetical defendant would be guilty of? Because it seems odd that we would give that individual a pass.
Yeah, I'd have to think about that. I imagine theoretically there probably is a crime that individual
But
could
it's
be
not
prosecuted
assault in
for,
your
but I
mind?
don't think it's assault because it doesn't satisfy the communicated threat requirement.
Well, but it's a little hard to imagine, right? Because I think your colleague agreed, if there's a third party that sees it, well, then it's a communicated threat, and that's an assault. It doesn't have to be perceived by the victim.
That's right.
So, but if there's not a third party and there's not a video, it's not a prosecutable event, right? Because we don't know
We don't know
it
that it happened. That's
Right? So
right.
it's a little odd to think about whether that's a crime or not. It would be a crime if somebody saw it, but it's not a crime if you don't get caught.
I agree with you on that front, Judge
Not even
Richardson.
for unicorns in that circumstance.
Not even for unicorns in that circumstance, but
What about if the defendant had a sort of a moment of contrition and just confessed and said, hey, nobody saw this, but I did it. I swung that axe.
Uncorroborated confession wouldn't help, right?
I don't think that would help. And, I still would have a hard time saying a prosecutor prosecuting that case on the basis of a defendant's confession alone to a crime that no one knows was committed and no one else witnessed. But I think all of this is sort of intellectual and interesting, and I'm happy to continue to engage, but I do want to just quickly jump to Judge Richardson's point from the beginning of Mr. Kilbourn's presentation, which is that whatever error the district court may have committed in treating Mr. Shade's conviction for assault with a deadly weapon with intent to kill as a crime of violence under 4B1.2, any error was harmless because the district court, considering all the facts in Mr. Shade's case, believed and repeated throughout the sentencing proceeding its belief that a sentence of 60 months would have been appropriate, or a sentence based on a calculation of the guidelines that did treat Mr. Shade's conviction for assault with a deadly weapon with intent to kill as a crime of violence baked into the guidelines calculation. And I just do really also want to quickly respond to the suggestion that maybe the district court did not properly or go through the exercise of properly calculating Mr. Shade's guideline sentence. The district court did consider each of Mr. Shade's objections to the PSR and ruled on each of those objections in reaching what Mr. Shade believes is an incorrect guidelines range, but a guidelines range nonetheless. And then thereafter went on to properly consider the 3553A factors in selecting a sentence near the bottom of Mr. Shade's advisory guidelines range. And just briefly, last point, related to the 3C 1.2 enhancement, I would just note that the district court properly determined that the nature of Mr. Shade's flight warranted the two-level enhancement under 3C 1.2. In this case, we cite at pages 44 through 45 of our brief cases where this court in unpublished opinions has affirmed application of the enhancement where the defendant engaged in a high-speed chase and there was evidence of additional erratic driving behavior that placed the public at risk of death or serious bodily injury.
Does it matter that the district court judge in this case sort of relied on his own personal knowledge of the road conditions and the like instead of, was there independent evidence of that?
I don't think so. I think it was appropriate for the district court to take judicial notice about, it wasn't the road conditions, but it was sort of the fact that the area through which Mr. Shade fled included and ran two red lights included intersections that are two of the busiest intersections in the southern part of Buncombe County. I think it was appropriate for the district court to take judicial notice of that. The district court didn't say anything about what the road conditions were on the day or at the moment of Mr. Shade's flight, but I do think that's a relevant consideration combined with just the mere fact that Mr. Shade drove against the flow of traffic to bypass stops traffic at two very busy intersections. We think that is enough for application of the enhancement here. I mean, we also just briefly mentioned in our brief that Mr. Shade had in his possession 3 or 4 firearms. We think that also elevated the nature of the risk to bodily injury, not only to the public, but also to police officers, especially because we're dealing with a defendant who has in the past used a firearm to shoot at police officers in attempts to undermine their execution of their official duties. If the court has no further questions, we will rest on our brief on the remaining issues, and we ask that you affirm the district court's judgment.
Thank you, Ms. Reed.
Thank you.
Thank you, Judge. I want to clear the deck of a couple issues before we get back to what I think is
We're back to
important.
the Titanic, is that?
Back to the Titanic. And it feels like that some days, Your Honor. A significant amount of our briefing obviously dealt with the Second Amendment issues, but other panels have been working very hard, including I think just about everybody up here at some point has visited that issue in some other case. So we would argue that while we're not conceding the issue, every argument we could have made or have made has been addressed by another panel. So it'll be another court that preserves any of those arguments for us if there's something in the future. But I did want to mention that because I know Ms. Reed had come all the way down here, and I didn't want to disappoint by not mentioning Bruin. The other thing, Your Honor, that obviously got some supplemental briefing was the issue of the motion to seal, and I think that there is some importance there. Generally, the government did not have a position at the time. I understand now they believe it's probably not a timely appeal, but I would encourage this court.
The district court's never ruled on it, have they?
The district court ruled once, and we filed basically a renewed motion on the same grounds. So it may be appropriate.
He said he was giving you a do-over.
He's given a do-over, he's given a mulligan. We would argue that there is some concern about the interpretation of the language that requires the balancing by the judge of these interests of the public in knowledge versus the protection
Well, if he
that
hadn't ruled on it, how
has
are we
not ruled
supposed to
on it.
consider it?
Well, again, Your Honor, I would love for this court, and again, I realize it may not be coming, I would love for this court to give some guidance to the district court on how to balance those issues in light of protected information. So,
Help, just from a perspective, I mean, we have a ruling that seems to be subsumed within the final judgment.
Yes, sir.
And so it seems like we have jurisdiction to review that. And obviously sealing questions often come up well after the final
Right.
judgment, and they're often addressed in different contexts, and you may have other arguments to be made. But do you agree we have jurisdiction to review the first denial?
I believe you do. I don't want to speak for the government, but I know,
I'm
they
only
have.
asking you.
We believe you do. We believe that there was a final order issue with a chance to renew the order.
And help me understand why you think the first order, forget what arguments you might or might not be able to make in a future proceeding, but just help me understand at its core, what do you think the district court got wrong in denying your request?
We believe that there is a certain category, just like we've already acknowledged, cooperation is a category, family information, children's information is a category. We believe that certain protected health information is also a category that should be given additional weight in the balancing test. That, for example, if a defendant says.
But do you suggest that it has to be a categorical rule, that like no medical information can ever be unsealed?
I don't believe it's a categorical rule, but I
Okay.
believe.
And so then why, I mean, the district court didn't seem to say, I don't care at all about this, right? He just balanced it differently. It seemed like to me he made a reasonable sort of set of choices.
I don't believe that, based upon his initial ruling, that he gave any weight to the fact that it was federally protected information, that this was health protected information. That, for example, if you're saying that I'm sick, and it's certainly relevant that I'm sick and that I have prostate cancer, but it's probably not relevant to unseal the medical records that talk about the exam, the operation to cure it and the after effects. That there is a line under which that a defendant doesn't give up all of his healthcare privacy rights just by arguing that there is an issue. And so that's the issue that I wanted to bring to your attention, that in that balance.
But I thought the court, and I need to go back and look at it more closely, but I thought the court basically said, like, listen, there may be some parts of this that you can seal, but you've asked to seal all of this, and that's inappropriate, right? That
Right.
whatever it is, you can't seal everything, including the very things that you're relying on in this case. And the question we have on that order, whether that ruling was like demonstrably wrong, that seemed to have been like an eminently reasonable ruling at the time. Whether you could prevail on some narrower claim is not before us.
Right. In the balancing test, he did not utilize the protected medical information and give it the weight that it should
So
have.
that he dismissed your motion to seal
Completely.
without prejudice.
Without prejudice,
With
completely.
leave to amend,
Yes.
which oftentimes would tell us that's not final. And if it's not final, we can't review it.
Well, again, that's for the three of y'all to work out. I know that there's difference of opinion. We believe that we renewed the motion on the same grounds. So it's gonna go back down there under the same condition that it came up here. But that's an important issue. But I would argue that if you look at the overall nature of this particular case, and if you look at what we're arguing is a significant procedural problem with assault with a deadly weapon being determined as a guideline sentence, we think that there's a problem with basically saying the guidelines are irrelevant. We believe that the guidelines must be decided first, and if you miss the first step, that harmless error shouldn't save you because you're starting from the wrong basis. And that would be our argument as to why this particular case should be sent down for resentencing. Thank you, Your Honors.
Thank you very much, Mr. Kilbourne. I know you've done this often, Mr. Kilbourne, to your credit. We want to thank you again for taking on this court-appointed work. We really appreciate all the lawyers who do it, and certainly you in particular for being frequently available to take on this responsibility. So thank you very much.
Thank you. I'm honored to do it, and I was worried you were going to call me a repeat offender, but I appreciate it.
And Ms. Reed, thank you very much for your argument. We'll come down and greet you both and move on to our second case. Be seated, please. Our second case is United States versus Suncar, 23-4765. Ms. Toma, whenever you're ready.
Good morning, Chief Judge, Your Honors, and may it please the Court. Jenny Toma for Rashun Sunkar. Of the three issues in this appeal, I'd like to begin with offers to sell. The argument that Pennsylvania delivery is overbroad because it includes offers to sell. Here we have two key situations or circumstances. We have a thoroughly reasoned authored opinion from the state's intermediate appellate courts stating that Pennsylvania subsection A30 includes offers to sell. We also have no persuasive data that the Pennsylvania Supreme Court would decide it differently if it agreed to take it up, which it has yet to do. Under the law in this circuit, these circumstances support only a finding that it is overbroad and does include offers to sell under Walker. It is an unpublished decision, but nonetheless, it's still the highest state court authority, and this court, as we mentioned in our recent 28J letter, does regularly rely on the highest available when it's an intermediate appellate court decision, which
Well,
it
we
is
don't
here.
usually give but so much credence to our own unpublished opinions. Why would we do any better for a state intermediate appellate court's unpublished opinion?
One reason is because it is the highest available authority. Another reason is because the court didn't have to reach the issue at all. It was initially an Anders brief, and they could have very easily just simply not taken it up. But they ordered further briefing, and they very carefully and thoughtfully considered the Third Circuit's opinion in Glass, and they concluded in a very, again, extensive reasoned opinion that they disagreed with the Third Circuit's interpretation of Pennsylvania law. And so, even if you disagree with me about that, I would say that at the absolute most you could say is that the law in Pennsylvania is uncertain. Because there are certainly, it is unpublished, but that doesn't mean that there are Commonwealth's attorneys who would say, Judge, I don't think you should enhance this sentence because this is an unpublished opinion. I feel sure that's not happening. And if any court could rely on it, which they do have the option to do despite being unpublished, I think that is not enough for this court. As this court, a different panel of this court said in Hope recently, a few years ago, in order to apply a federal sentencing enhancement, this court should have clear signals. That's the quote, clear signals, and you should be convinced to a certainty that the state law isn't overbroad or is not overbroad before you apply a federal sentencing enhancement.
Does it matter that the principal issue in Walker was whether or not the Pennsylvania statute was a match for a separate New York State statute, and the secondary analysis was dictum and not really part of the holding of the case, on top of the fact that it's unpublished?
I don't think it matters that they were analyzing whether it was substantially identical to a New York offense, because the New York offense also includes offers to sell. And so I think that's a distinction without much practical difference for our purposes here in federal court, personally. I mean, I know that it is a different question, but whether or not it includes offers to sell, and like the New York offense, is really relevant to what we're taking up here today.
What about the fact that the Third Circuit, even after Glass and with the benefit of Walker, has continued to suggest that Walker is simply wrong?
There are two, as we again said in the 28J response, the first case that the government raised, Hurt, just doesn't apply here. It considered different issues that aren't what we're raising. The other two, Brown and Magabet, did little more than simply just observe that they were bound by Glass, that Glass was binding on subsequent Third Circuit panels, which they were, and that, they didn't do much more than simply that, to say that we are bound by Glass and that we are bound to follow it. Even if they disagreed, that was still, at the end of the day, something that they had to do. This court, of course, labors under no such handicap. There is no precedent that binds you, and so you're free to consider Walker on its own merits, whatever those might be. But again, we do feel that even at worst for us, there's just, Pennsylvania law is unclear, and courts could be enhancing sentences on that basis of Walker, even though it's unpublished, and we don't think that that's sufficient to apply a federal sentencing enhancement. Now, ultimately, state courts are the final arbiters of state law, and I do think that that's correct. I do think that there should be
But
some
haven't we,
deference.
in almost every setting, including the criminal setting, we've said that our responsibility is to anticipate what the highest court of that state would do. So even if it was a published appellate court decision, we've said repeatedly, we're not bound by that.
Sure.
Right? It may be bound if the highest court in that state has ruled, but otherwise, our responsibility is to anticipate what the highest court of that jurisdiction would say.
That's right.
And so, can you help me a little bit understand, like, why you think Walker is right? I mean, I'm sort of baffled by Walker's reasoning, to be totally fair. And so I understand you want to say we should just follow it blindly
Sure.
into the night, right? But assume for a minute, I don't think we should do that. We should actually just consider it like it was a law review article or a brief, and sort of, if it's persuasive, great. If it's not, then it's no more interesting than a newspaper article.
Sure.
So why would I think it's right, particularly given the distinction the statute makes between delivery and offers for sale in the same statutory provision?
That's right. The first thing I would say is that there has to be, under the law of this circuit at least, there has to be some persuasive data that the Supreme Court would decide it differently. And I think the government has not offered any of that here.
No, we
gotta
have
have
to have confidence in what the highest court of the land would say if asked this question,
Sure,
right? We don't have to, the whole point of this inquiry is we don't have to have a decision from the
that's right.
highest court in the land.
But the government does have to offer this court, or it has to have some persuasive data that the Supreme Court of Pennsylvania would decide it differently. That is what
And
it's followed in the
they've offered the
past.
statute, and they say, read the statute, it's pretty darn clear. And that seems like a reasonable argument to make. And so that's what
Well,
I'm asking is,
sure.
why is that not, like, help me understand why you think Walker is correct, rather than why you think we should just follow it blindly.
Walker had two rationales, and one of them was that it disagreed with the Third Circuit's idea that the Third Circuit in Glass basically said there's a subsection A1 that is drugs that have been adulterated or misbranded. It expressly includes offers to sell in the text. A30, therefore, the Third Circuit reasoned, doesn't have offers to sell. That must have been evidence or, good enough for us that the Pennsylvania court didn't include regular deliveries to include offers to sell. And that's what they disagree with. They say, for two reasons. They say, first of all, we don't think that the omission, we're interpreting the omission differently, right? We don't think that that's evidence that they didn't intend for it to be in A30, and we do think that they've left that possibility wide open. And so that's what we are interpreting.
I understand that
our research.
argument.
Okay.
Let me maybe ask it a different way.
Okay.
Do you think Walker's right for any reason that is not included within Walker itself? So in other words, do you think Walker reached the right result for some other reason other than what I understand what Walker said. I totally get that, and I wasn't clear in my question. Do you think there are reasons that are not included in Walker that suggest that it is right? Or am I just looking to the reasons as they are that Walker provided?
I think the most compelling reason for me is that even if we might disagree, that state courts get to decide what their own law means. And my best reason is perhaps a practical one or a logical one, which is that if you rule in the government's favor, we will have a Pennsylvania predicate that is simultaneous, it'll be Schrodinger's predicate, simultaneously broad enough to include offers to sell when Pennsylvania would like to hammer their defendants, and simultaneously narrow enough to not include offers to sell when the government would like to hammer our clients. And that just cannot be, as a matter of practical, that cannot be. So I think there are several reasons, but ultimately.
That's not a reason why, I mean, you understand, that's not a reason why Walker is correct.
Sure,
Right?
but
That's a reason to follow Walker blindly into the night, right? And that may be a good reason.
Sure.
I'm just trying to bracket that reason, that we just blindly follow it because it is, as opposed to we should follow it because it's correct in some meaningful way. And maybe we just follow it blindly. I totally understand that argument. I just wanted to make sure I understood all the arguments you have for why you think the decision is legally defensible and correct.
I think that reasonable minds could arrive at either conclusion, but that the state court has arrived at this one. And so, but I would disagree that you're so limited. I mean, of course, it's unusual, but this court always has the ability to certify if it wishes.
So, but why would we think that the Supreme Court of Pennsylvania would arrive at the conclusion that you proffer here?
I think that it's probably a 50-50. I don't know what the Supreme Court of Pennsylvania would do, and I don't think any of us know what they would do. I frankly am surprised that Walker decided to take up an issue that was in an Anders brief. I don't know why they reached so far and considered it so thoroughly to begin with. It was clearly something that was important to the panel. But I do think that, I don't think any of us know for sure what the Pennsylvania Supreme Court would do, and I think it's that uncertainty that counsels against applying this enhancement for federal purposes.
Well, it was
And I would
somewhat
say-
important, I guess, because it was, I agree with you that it was important enough to take it up in an Anders brief, but not so important that they would publish.
Well, that's a fair point. I will concede that point, but I'll also, surprisingly, it's been 3 years since Walker was decided, and the Pennsylvania Supreme Court has yet to step in, which I also personally find puzzling. I would think it would be something that they might, but it hasn't done so yet, so here we are.
Well, they may think that we don't really need to fool with unpublished intermediate court opinions.
That's possible. It's also possible they might agree with it. It's hard to say.
Or that just nobody's prosecuting offers to sell under that statute. So the issue doesn't come up, right? The reason, we see it in this unusual context there, but we don't see it in the context of a Pennsylvania court actually prosecuting an offer to sell.
Sure. The empirical data test, of course, though, has been discontinued. So just in case that's what you were thinking, I wanted to be clear about that.
Well, we're trying to understand, you said Supreme Court would have fixed this. My point is, like,
Yeah.
the most likely scenario is that these prosecutions are not being brought, right? That's why we have no case law suggesting that they could be brought.
Right, I think it probably is certainly a minority, a vast minority of what comes up under that statute, but it also, in this instance, only arose for a sentencing enhancement, not even a prosecution. So you're right, that may very well not come up every day. It probably doesn't. I'm happy to take any further questions on that if the court has them. Otherwise, I'll move on to the reasonableness of the sentence. I guess just to address them in backward chronological order, in our other 28J recently, we pointed out that another panel of this court recently found the same judge a different sentence that was similarly unexplained and arguments similarly unaddressed in a different case in the United States versus Prater was unreasonable and remanded it. And the same circumstances are present here.
Can you tell me where in your brief you make that argument?
It's in our reply brief.
So help me understand why that matters to me at all. I totally understand this argument, right? And
Right.
I confess I was a little surprised, but when I went back and looked, I don't see any suggestion of substantive unreasonableness that's made outside of, the arguments that we've been talking about in the opening brief.
That's right. It's a great question, Your Honor. I think that I would just point the court to Provence, in which this substantially identical thing happened. The government appealed a sentence that had an unexplained downward variance. And in Provence, the government not only appealed only the substantive reasonableness of the sentence, they expressly disclaimed at oral argument that the sentence was even procedurally reasonable. And this court held that it must.
But the difference we have is you haven't raised the substantive reasonableness argument, right? Like you just raised the guideline calculation error.
We did raise the substantive reasonableness in the reply brief, but not in the opening, yes.
I'm just
trying to be clear.
I understand in the
I'm sorry.
reply brief, but
That's
you
right.
understand that doesn't do enough, I think, in most instances.
I would disagree, because in Provence, it didn't matter that the government hadn't raised it in their brief, and the court found, Judge Motz said that we are obliged, the court cannot reach the substantive reasonableness of a sentence until it has satisfied itself that no procedural errors occurred. And of course, here there were 3. There's the one, of course, we raised in the opening brief, the procedural error and the guidelines error.
And you think it goes both ways. So you raised a procedural error, and therefore you think we are required to do a substantive review? I mean, that seems
Actually-
odd. You raised a specific objection in the opening brief. And then I understand in the reply brief, you come back and say, yeah, but you ought to consider this other error too, that's not raised in our opening brief. But that seems like the other direction from what Provence was doing, right?
Actually, the government raised substantive reasonableness in its brief, and so therefore it was really responding to that. And it's like, well, if you're going to get into the substantive reasonableness of the sentence, then you must first satisfy yourself that no procedural errors occurred. And I think Provence is squarely on point to that. I think that's very direct.
Maybe I'm not following. It would be on point if you had raised a substantive reasonableness claim in your opening brief, right? But
I don't think that, no, in Provence, it was also not raised originally. I think that that's what we have in common, is that Provence, there was no raising of the procedural issue originally. And the government did bring up substantive reasonableness, which is something that we didn't initially appeal.
Well, if we disagree with you on your procedural reasonableness arguments, wouldn't that be the end of it?
On the, I mean, I guess it depends on if your honors disagree with me about Provence.
I guess I'm not understanding that at all. If you've made procedural reasonableness arguments, we don't find they're meritorious, but you
Oh,
haven't made a substantive
yes.
reasonableness argument, how would we ever get to that?
That's right. No, I'm sorry, you're correct. We would agree with that.
All right.
But if I understand your point is that if you win on the first issue, the government is saying, well, even if you win on the first issue, that error is harmless because the sentence is otherwise reasonable. And you're responding to that argument.
Yes.
So that it's a bit of a different context.
Perhaps there are some.
I'm actually agreeing with you.
Yeah. No,
You're okay.
I'm just saying that I think that the points that we have in common are relevant. That's all I'm saying.
Okay, thank you.
Thank you. All right. Finally, with the time left.
You don't have any time left.
Oh, okay. Sorry, I saw 105. I didn't realize it was in the wrong direction.
But you have some time left on rebuttal. Ms. Nogue?
Good morning, Your Honors. May it please the court. The district court properly deemed Mr. Sunkar a career offender because his prior convictions under the Pennsylvania Drug Distribution Statute, A30, are controlled substance offenses under the plain text of Section 4B 1.2 of the guidelines. The Pennsylvania statute is not overbroad by conduct because it does not criminalize offers to sell or attempt offenses. And I'll begin with the offers to sell argument. Pennsylvania law simply does not criminalize offers to sell. A30 clearly makes it a felony to manufacture, deliver, or possess with the intent to manufacture or deliver a controlled substance. The definition section further defines delivery as the actual, constructive, or attempted transfer of a controlled substance. The statute is notably silent as to offers to sell. Now, as we mentioned, at least one provision contained in Section 780.113 does expressly prohibit offers, and that's Section A1. And Section A1 criminalizes the manufacture, sale, or delivery, holding, offering for sale, or merely simple possession of any controlled substance that has been adulterated or misbranded. So that is entirely separate from Section A30. And the offering to sell language, as I mentioned.
But the Walker Court seemed to think that that was relevant with respect to interpreting the statute that we have before us. So what about that?
Yes, Your Honor, I would agree the Walker Court found that relevant. Similar to Judge Richardson, I am equally baffled by the Walker Court's reasoning. I don't think it makes any sense. I think the fact that that offering for sale language is absent from A30 shows that the Pennsylvania legislature did know how to criminalize offers to sell, and they simply chose not to criminalize offers to sell in Section A30.
So if Walker had been a published opinion, would that change our discussion?
It would, Your Honor. I think it would change the discussion entirely. However, Walker is not a published opinion. It's an unpublished
But
memorandum.
why is that? I mean, it would still be an appellate court decision, right? Wouldn't we still have the obligation as a court to determine what we think the Supreme Court would do?
Yes, Your Honor. I think even if Walker were a published opinion, the burden would then be on the government to produce some evidence that the Supreme Court would decide the decision differently. However, Walker is not a published opinion, and by the Superior Court's own rules, it can only be cited for its persuasive value. It's not binding on the PA Superior Court. It's not binding on a single trial court within the entire Commonwealth, and it's certainly not binding on this court. And my colleague brought up the two cases that were decided by the Third Circuit this summer, Magabet and Brown. And, Your Honors, if Walker were an authoritative decision, if it were intervening, controlling law out of the state of Pennsylvania, the Third Circuit would have been required to follow the holding in Walker. But the Third Circuit was not required to follow that holding. They acknowledged the Walker decision, and they said, we're not persuaded by it. And while Magabet and Brown were both subject to plain error review, I believe it was the Brown court that said that argument would fail even under de novo review. So, Your Honor, the holding in Walker simply does not affect this court's analysis of whether Pennsylvania criminalizes an offer to sell. And, Your Honor, I agree with my colleague that the empirical data test doesn't apply, but Duenas-Alvarez still remains good law. And Taylor limited it to a certain situation. The defendant has to prove that the state applies the statute in a special, non-generic manner. Mr. Sunkar cannot do that. Again, the only suggestion Mr. Sunkar has that Pennsylvania criminalizes offering to sell is this Walker case, which is just unpersuasive. And, Your Honor, this case actually has addressed this exact issue before in United States versus Johnson. Johnson dealt with a Maryland statute. The defendant in that case had a conviction for possession with intent to distribute. That Maryland statute, the defendant argued that the Maryland statute criminalized an offer of distribution. And this court looked to the holdings of our sister circuits, and they found those opinions and those holdings quite instructive. Because our sister circuits who have looked at this issue, those state statutes expressly criminalized an offer for sale. For example, the 10th Circuit, the Kansas statute expressly criminalized offer for sale. The 5th Circuit looked at a Texas statute which expressly defined deliver as offering to sell. In contrast, the offering to sell language was notably absent from the Maryland's criminal code. And this court rejected the defendant's argument that the statute criminalized a mere offer to sell drugs. And for the same reason, because the Pennsylvania statute is silent, this court should reject that argument here as well. Your Honors, if there are no additional questions as to the offering to sell issue, I will move on. Actually, I apologize. One other thing I wanted to point out. I do think it is significant that the Walker court, they were comparing the Pennsylvania statute to a New York statute. And I think that that's significant for one reason. The Walker court held that in sum, they concluded that the New York offense is substantially identical to the delivery offense under Section 830 in Pennsylvania. But what's significant is that the New York statute, Section 220.00, only criminalizes bona fide offers to sell. It's well established under New York law that it must be a bona fide offer in that the defendant must have both the intent and the ability to proceed with the sale. The First Circuit in United States versus Bryant looked at that statute, 220.00, and they held that that statute does in fact qualify as a predicate offense under the career offender enhancement because it requires the possession and the intent to distribute or dispense. And the Third Circuit actually followed that holding of Bryant in United States versus Santana, finding that that same New York statute did in fact qualify as a predicate offense for a career offender enhancement. And here all Walker says is that the Pennsylvania statute is identical to that New York statute. Turning now to the attempted transfer argument, it appears from this court's holding in Groves that the determinative question is whether there exists a separate statute for attempt crimes that would be rendered superfluous by finding that the relevant drug statute encompasses attempt crimes. This court again reiterated that in two similar cases, Davis and Miller, holding in both that attempted transfer is a completed distribution. And Pennsylvania also codifies attempt separately. The government cited several Pennsylvania cases in their response brief that demonstrate attempted delivery is charged under the general attempt statute, section 901, rather than by charging a violation of section A30 and then invoking 102B's attempted transfer definition. For example, Commonwealth versus Bernard, that was one of the cases that was cited. That's from 2019. Again, that upheld a conviction for attempt to deliver a controlled substance that was charged under Pennsylvania's general attempt statute.
I think I know your answer to this, but just to ask, in Campbell, there was a general attempt statute in West Virginia. I know it wasn't mentioned by the court, but it seems odd that that is the line that you draw out of Groves, Miller, and Davis, when Campbell itself, the state had such an attempt statute and the court, didn't find that to be pertinent. Help me understand why that ought to be the line.
Yeah, I agree, Your Honor. And as the court noted in Groves, that was brought up in the briefing and argument in Groves that West Virginia actually does have this separate attempt statute. And the court in Groves indicated that, number one, that wasn't an issue before the court, so they weren't going to take it up. They also indicated that that could actually speak to the proper construction and proper interpretation of the West Virginia statute. I would note that the parties in Campbell, they agreed that the least culpable conduct criminalized by the West Virginia statute was an attempted distribution. And this court didn't really do any further analysis into the least culpable conduct
The parties
criminalized.
didn't really ask them to.
Correct. The parties did not ask the court to. They mistakenly, and my office was involved in that, my office mistakenly agreed that the least culpable conduct criminalized was an attempted delivery. Here, the least culpable conduct criminalized by the Pennsylvania statute is not attempted delivery. Rather, it's a completed delivery that can be completed by the means of an attempted transfer. But the act of delivery is a completed offense. And Your Honor, the Third Circuit has held that in United States versus Dawson. The Third Circuit has considered this issue and held that under Pennsylvania law, attempted transfer is a completed delivery offense. The Third Circuit in Dawson noted that to hold otherwise would be inconsistent with Pennsylvania attempt law in two ways. First, criminal attempt is defined in Pennsylvania as the intent to commit a specific codified crime. Transfer is not a codified crime in Pennsylvania. So transfer is not a codified crime, so you cannot attempt a transfer under criminal attempt law in Pennsylvania. Rather, transfer is simply the factual means of completing the crime of delivery. And the Dawson court also noted the other inconsistency is in Pennsylvania mens rea law. Under general attempt law in Pennsylvania, one must have the specific intent. To interpret attempted transfer as an inchoate offense would be inconsistent with this mens rea case law because the specific intent would have to be the applicable mens rea. However, by the delivery statute itself, the applicable mens rea is mere knowingly. So it would be an inconsistency within the statute itself, and the Third Circuit refused to hold in that way. And finally, I just want to point out, as Judge Agee stated in his Miller opinion, to hold that Pennsylvania drug distribution statute is not a predicate offense for the career offender enhancement would be remarkable. And it would result in several other state drug trafficking laws not qualifying, and that cannot be what the Sentencing Commission intended. Your Honors, if you have no additional questions, we would ask that you affirm the judgment of the district court.
Thank you very
Thank you.
much.
Thank you, Your Honors. A few points in reply. Johnson, we concede, would apply if Walker didn't exist. But because Walker exists, and concluded that the offers to sell language that's present in A1 is also fairly encompassed within A30. Johnson is just not on point to this situation. Second, Walker didn't parse out anything about whether the offer had to be bona fide or not. It's not so, nothing in the terms of Walker so limited it in that way, even if New York has, or even if the Third Circuit has, Walker simply didn't do it. If any trial court could rely on Walker, which they do have the option presently, that's enough. Moving to attempted transfer, it's not relevant how attempted delivery is prosecuted because, as we said in the briefs and here today, the empirical data test has been discontinued. And so to the extent that some of these Third Circuit opinions rely on it, that also post-Taylor is incorrect as well. Ultimately, it doesn't matter whether there are 2 criminal statutes that criminalize an attempted drug offense or whether there are 3, because those aren't superfluous in any case for all of the reasons that we belabor in the opening brief. Surplusage does not exist just because there are 2 statutes that happen to cover the same crime. And the same is true if there were 3. That's just a distinction without difference.
So
However,
what do we do with Groves, Miller, and Davis, which seem to just disagree with your point there? I mean, they seem to say that it is, and I understand the logic of your argument, right? But what do I do with Groves, Miller, and Davis, who all seem to say that superfluous argument prevails in this context?
actually, Groves, Miller, and Davis didn't address any of the cases that we've cited in these briefs. They've not been addressed at all in those opinions. I would also note that this court in those opinions has made a practice of distinguishing Campbell on that basis. And so, you know, for it to,
Distinguishing it on what basis now?
on the basis that there's just simply a general attempt statute and not a drug-specific attempt statute. So, you know, to the extent that it relied on that basis to reach those decisions in each of those subsequent cases in Groves and Miller and Davis, you know, you would have to then walk that back in order to differentiate this one here, which is like the West Virginia statute. The mens rea difference, speaking of superfluousness, the mens rea difference that my colleague brought up very handily supports a finding that the statutes aren't superfluous because it clearly points out a difference between them anyway, beyond what we've identified. But the difference in mens rea also helps explain very handily why these statutes simply aren't superfluous in any case. I'm happy to take any further questions that the court may have with respect to any of these issues.
Thank you very much, Ms. Stoner.
We'd ask that the court vacate the sentence and remand. Thank you, Your Honors.
We thank both counsel for their able arguments. We'll come down and greet you and take a brief recess before moving on to our final 2 cases.
This honorable court will take a brief recess. Honorable, the judges of the United States Court of Appeals for the Fourth Circuit.
All right, be seated, everybody. The third case is 24-1350, Employers Innovative Network LLC versus Bridgeport Benefits, Inc., and other parties. Mr. Ford?
Thank you, Your Honor, and may it please the court. My name is Jay Ford, and I represent the appellants in this matter, Employers Innovative Network, LLC, and Jeff Mullins. And the issues before the court today arise as a result of an arbitration in Bermuda that is illegitimate in two fundamental respects. First and foremost, the district court lacked jurisdiction to compel the arbitration to proceed in Bermuda and then to subsequently enforce the arbitration award that was rendered there. In fact, the district court lacked any jurisdiction over, any subject matter jurisdiction over this matter at all. And secondly, the arbitrator's undisclosed conflict
Well,
of
you're a
interest.
little late in the game to raise that, which of course we have to always address, but
You are right, Your Honor, but as this court is aware, federal courts have a special obligation to satisfy itself,
Right.
not only of its own jurisdiction, but that of the lower court. And subject matter jurisdiction is a non-waivable defense, even if the parties fail to address it.
So that raises the question as to whether or not this issue regarding the district court's ability to act under the New York Convention is actually jurisdictional, because you had diversity jurisdiction, right? The district court found diversity jurisdiction when it denied the motion to remand. And in fact, I think found that all of these parties were domestic parties. You say you weren't sure about that, but I think the district court found that there was this corporation that may have been incorporated in Bermuda but headquartered in Florida, so it appears there's diversity jurisdiction. So with that, is the argument that there are two requirements for jurisdiction, subject matter jurisdiction here?
No, Your Honor, but it fails under both tests, and I'll tell you why.
Okay.
So first, addressing diversity, which is how the case was initially removed to the district court in the first place. In the notice of removal, the defendants assert that EIN citizenship that EIN was a West Virginia LLC, which is principal place of business in West Virginia, and that Voluntary Benefits was a Florida LLC with its principal place of business in California. But an LLC's citizenship is determined based upon that of its members, not its principal place of business or charter state. Now, certain defendants did assert a printout
But
from.
the district, with respect to EIN, the district court found that there was diversity, and you have not challenged that. So they found that you were EIN was a diverse citizen, and then you put forward, and it's your client, you put forward no evidence to challenge that finding. So don't we have to find that district court determination is clearly erroneous?
I don't.
You haven't given any evidence, right? I understand you got a little gamesmanship story going on where you don't want to tell us who the LLC members are. We could order that, that's totally fine. But it seems odd where the district court makes that finding, you then don't challenge it. And so we have a district court finding that your client is diverse.
And I guess that's true. The district court did find that. But the district court found that based upon.
And are you representing as an officer of the court that your client is not diverse? That the members of the LLC are not diverse? Are you representing that to the court?
I'm not making that representation, Your Honor.
Right.
Frankly, I don't know. But the district court didn't either. And that's why diversity wasn't established in the underlying case. Because the evidence that the district court relied upon to find that EIN and, for that matter, voluntary benefits that the complete diversity rule was satisfied were printouts from the West Virginia Secretary of State's website,
But you didn't argue a diversity issue, did you?
It was challenged on a motion to remand that was ultimately the district court dismissed. But again, we raise it here in the context of because there's not diversity jurisdiction and because there's not jurisdiction under the New York
Well, let's
Convention.
assume there is diversity jurisdiction. And then we move to this other question that Chief Judge Diaz pointed out. So now you have this question of authority under the New York Convention. So what particular animal was that? Is that subject matter jurisdiction or is it something else?
It's subject matter jurisdiction, Your Honor. And the reason why it's important in this case is that Section 4 of the Federal Arbitration Act generally only permits district courts to order arbitration within their own district. And so the only basis to compel an arbitration outside of a district is Section 206.
I'm sorry, I don't understand this at all, right? You filed a suit, right? And if we accept Judge Agee's hypothetical, like the district court had jurisdiction over that suit that you filed once it was removed because of diversity.
Assuming, yes,
Assuming, yeah, we're making an assumption, right?
Understood.
And so your argument is that the FAA deprives the court of diversity jurisdiction? So they had needed to dismiss, your original complaint was required to be dismissed under 12B1?
I don't believe that's what I'm arguing, Your Honor.
If it's subject matter jurisdiction, then it has to be dismissed under 12B1. That's why I don't understand your argument.
Sure, well, the only law that gives a district court the authority to order arbitration to proceed in a different district beyond its own is Section 206 of the Arbitration Act. And both 206 and 207, which is the corresponding section that gives the district court the power to enforce a form of an arbitration award, but requires the district court to have jurisdiction under the New York Convention. And that's not present here, and that's addressed by Section 202.
That's the only authority under Chapter 2, but there's authority under Chapter 1.
And Chapter 1 provides that a district court can, I think the only way a district court can order arbitration outside of its own district is if the arbitration agreement falls under the New York Convention. And that's addressed by Section 202.
I thought the Supreme Court said that those are just venue provisions that are waivable, right? The location of where the enforcement happens under Chapter 1 are venue provisions. They're not jurisdictional provisions, and so they're waivable. And nobody's sort of argued that.
We certainly did not argue that, and I don't recall the appellees raising that in their briefs either.
Yeah, I understand the appellees didn't argue it. But your basis for it being jurisdictional is that it can't be done in this district under Chapter 1? That's your jurisdictional argument?
Correct, Your Honor, that it has to fall under the New York Convention for the district court to be able to compel arbitration in Bermuda in the first place and to subsequently enforce the Bermuda award without satisfying Section 207, which is the only basis for the district court to confirm a foreign arbitration award. And that requires the arbitration at issue to fall under the New York Convention.
Well, I don't think the district, I'm sorry, go ahead.
I mean, that seems to come back to the same threshold question. If the court enters an order under Section 2 that's not authorized under the statute, is that merely an error of law, or are we still on some form of subject matter jurisdiction?
I believe that's a subject matter jurisdiction question, Your Honor.
And tell us again why that's the case.
And that's because the only basis, the only power that, federal courts are courts of limited jurisdiction and are only authorized to act in ways that are recognized by Article 3 of the Constitution and statutes promulgated by Congress. The only way for a district court to enforce a foreign arbitration award is for that foreign arbitration award to fall under the New York Convention.
So just so I understand, tell me why they couldn't do it under Chapter 1?
Because because Section 202 is the only statute that allows a court to enforce a foreign arbitration award.
But I thought the territorial rules under Chapter 1, Sections 9 through 11, were permissive. They're not mandatory. So any district court could enforce, right? That seems like what the Supreme Court said in Cortez Byrd in 2000.
I don't believe so, Your Honor. My understanding is that, Section 202, and that's the only statute that's cited by the district court in its enforcement opinion.
Yeah, we understand that maybe the district court cited the wrong statute, but it's either a Chapter 1 or Chapter 2 case. Your argument is if it's not Chapter 2, it cannot be Chapter 1. And what I'm having a hard time understanding is why it cannot be Chapter 1. What is the provision that you're relying on for that idea?
It's Chapter 2. I mean, if it could happen under Chapter 1, there would be no need for Chapter 2. Chapter 2 would be completely superfluous.
Wouldn't be superfluous because it would apply to foreign arbitrations.
And that's
right?
what we have here.
Where the Section 202 provisions are satisfied. If they are not satisfied, then it doesn't fall under the convention and it's a Chapter 1 case.
I would argue, Your Honor, that if it doesn't fall under Chapter 2 and it's a foreign arbitration, it falls outside of the New York Convention, it falls outside of the FAA, and there's no authority to.
So entirely U.S. parties that engage in U.S. conduct, but if they choose a forum abroad for the arbitration, then in your view, contrary to all the other circuit courts, U.S. federal courts lack jurisdiction to enforce that arbitration.
If it falls under the New York Convention, yes.
Well, I mean, the district court never decided that, right? And whether or not you're right, I suspect you may not be right, I think the district court would have had to have looked at that and decided whether or not it had jurisdiction. And if it did, then decide what the remedy would be with respect to the motions that were before the court, either to vacate or confirm and respond to your arguments about evident partiality, which is may or may not be the same analysis under Chapter 2 as under Chapter 1. But this, I want to go back to Judge Agee's and my concern. You say this is subject matter jurisdiction, but the court had diversity jurisdiction. So it seems like we're doing jurisdiction twice over. Why is that?
We're doing jurisdiction twice because it fails under both, and those are the only two sources under which the court could have jurisdiction at all.
I'm not sure that is.
Well, we know the FAA doesn't independently provide jurisdiction, right? So either there's diversity jurisdiction or not. But if there's diversity jurisdiction, then the district court had jurisdiction. It may not have had statutory authority, we can debate that, but it had jurisdiction if we accept that there was diversity jurisdiction. I understand you
Sure.
are sort of half arguing that, but if they had diversity jurisdiction, then the court had jurisdiction. It may have made an error in applying the wrong statute, but that doesn't deprive it of jurisdiction, does it?
I think so. I think it doesn't have jurisdiction to compel an arbitration in a foreign country. If the subject matter of the case is, is whether the arbitration can be compelled in Bermuda. There's no authority for the district court to do that beyond Section 206 of the FAA.
So if I understand your argument, if there had been a failure of diversity jurisdiction in this case, your position is that the district court would have had independent jurisdiction under Chapter 2?
Under Section 203, because that provides that cases falling under the New York Convention are falling under the laws of the United States and would have federal question jurisdiction.
Although in this case, it fails, you say.
Correct.
Well, just help me remember what transpired here. The Bridgeport or somebody affiliated with them filed an application in the district court to have the arbitration award confirmed.
That's correct.
Correct? And in the application, they asserted that it was the provision of the New York Convention that authorized the court to act?
Yes, Your Honor.
That's correct. So was the issue of the other section, Section 1, was that ever raised other than by you in saying it could be vacated under that? Was that ever raised as a...
Under Section 1 of the FAA?
Yeah.
There was no discussion, I believe, of Section 1 under the FAA in any of the proceedings below. It was all grounded in the sections implementing the New York Convention, which are Sections 206 through 209, or 201 through 209. And under the New York, in order for a case to fall under the New York Convention.
So can you tell me, maybe this will help me. Hypothetically, accept that I think there's diversity jurisdiction, but also that Chapter 2 does not apply. So the New York Convention does not apply. Tell me what you think the decisional language of this court would read. We would vacate, and what is to happen when it gets back to the district court?
The district court if it would conduct, assuming this court determines that the New York Convention doesn't apply, it would not be able to compel arbitration in Bermuda. It could compel arbitration.
The argument would be, you would have an argument about whether Chapter 1 permits having compelled the arbitration or not. But that would be a question. I understand you have a view on that, but that question the court would have to decide is whether Chapter 1 permits it to compel arbitration in Bermuda.
Yes, I think that it would be a question that would have to be decided, Your Honor.
And then if not, then your theory is that your claims for damages can just go forward in federal court without any arbitration.
Assuming there is diversity.
Yeah, that's the premise to my question.
Understood, Your Honor, yes.
And that's because you think there's a gap for a case that fails to fall in the convention, but includes a foreign location for the arbitration. Then that doesn't fall in either Chapter 1 or Chapter 2.
That's correct, Your Honor.
So this issue under the convention was, we brought it up via supplemental briefing. So why wouldn't a more appropriate remedy be to send it back to the district court to decide whether or not the case actually falls under the convention? It didn't address that issue at all. It simply saw an agreement applying Bermuda law, appointment of a Bermudian arbitrator, and said, that's good enough for me. But it turns out that may not have been good enough under Chapter 2. So why would we decide that in the first instance?
Is there permission to continue, Your Honor?
Well, yeah, I asked the question. Go
Fair
ahead.
enough. Then I think that would be a reasonable remedy in this case. There certainly was no district court didn't have any sort of analysis as to whether this arbitration did or did not fall under the New York Convention.
Absolutely.
So this really is for both counsel. So let's just assume that the court determines either to let the district court in the first instance address Section 2, or Section 2 doesn't apply, and it goes back. In order to have Section 1 considered, would the application have to be amended to include a Section 1 argument?
I would think so, Your Honor, because that wasn't raised in the initial briefing to compel arbitration in the first place.
Okay, all right.
Thank you very much. Ms. Cooper?
Your Honors, may it please the court, my name is Jamie Cooper, and I represent Capital Security Limited, Universal Risk Intermediaries, and Gina Nordstrom. I will be addressing the subject matter jurisdiction issue, the applicability of the New York Convention, and if I have time, the waiver that resulted from Appellee's failure to exhaust his review of the substantive issue within the course of the Bermuda arbitration. I would argue, Your Honors, that subject matter jurisdiction exists by virtue of diversity, and that was clear. And although appellees now...
So help me just answer why you think that was clear.
Okay.
Because you allege the principal place of business of an LLC, and that is obviously irrelevant for an LLC citizenship.
Right, Your Honor. The district court was concerned about this issue, and before entering the court's order on enforcement, specifically asked the parties to submit a joint submission on citizenship of the parties. And in that joint submission, which is the underlying document number 272, the parties collectively went through the jurisdiction of each of the parties, and
So this is docket entry 272, and what does it
Yes,
say
Your
about
Honor.
the members of EIN?
It says that the three members of EIN were Jeffrey Mullins, William Edward Mullins, and Gary Bowling, and at all points between the time of removal and the present, they were residents of the state of West Virginia. Interestingly, Your Honors, although the notice of removal admittedly did allege the principal place of business for Capital Security to be Florida, in subsequent submissions to the court, it was alleged to be Bermuda and never challenged.
So what is Capital Security? Is that a corporation or some other type of?
Capital Security is it's a corporation organized under the laws of the state of the country of Bermuda, and so it's Capital Security Limited.
How do we know that? I mean, what's the authority? Because it's Capital Securities Limited, and they have all types of business organizations. So how do we know that's the equivalent of an American corporation?
Your Honor, I don't know the answer to that question, but I do know that it was asserted and never challenged below that Capital Securities is a Bermuda entity. It's a Bermuda insurer, it's a Bermuda segregated captive company under the Bermuda Segregated
The reason I
Act.
ask that is that circuit courts seem to be a little split on what to do with some of these foreign entities as to whether or not they're the equivalent of a corporation. And then that leads to the questions we're addressing here. And it doesn't look like to me there's necessarily a definitive answer in the record.
And I think that's right, Your Honor. Our allegation in the joint submission is that Capital Security is a Bermuda corporation organized under the laws of Bermuda, and that its principal place of business was in Bermuda, which,
So go back to that, right? So like,
Sure.
you alleged in your notice of removal that your principal place of business was Florida,
we did, Your Honor.
right? And so help me understand why I should ignore the allegation that you made.
So that was a mistake, and in our, in subsequent pleadings twice, in the joint submission, but also prior to that, in our response to, I believe it was the motion, or in our motion to dismiss papers, we asserted that the principal place of business was Bermuda. The allegation in the notice of removal was a mistake. I will submit to you that we believe that it was a procedural defect that can be amended by interlineation, as this court has done previously in Jaffe Spindler Company versus
Well, did the
Genesco.
district court ever make a finding on, I mean, you've got two different positions you've taken in the district court. Did it ever enter a finding as to which one it thought was correct?
It never addressed the issue beyond asking the parties for the joint submission on citizenship. And once that was presented to the court, no challenge, nothing was raised about the question. Nobody brought it up, and the court, I believe, accepted it, but didn't address it specifically.
So I take from that, that you're supportive of the chief's suggestion that because the district court didn't consider whether the New York Convention applies, and considering whether the New York Convention applies might well turn on whether the principal place of business of Capital Security is, among other things, that the best course of action here would be to vacate the order and send it back to consider whether the court applied the correct law?
Your Honor, I think the correct course of action is to affirm the court's decision because
All right, well, let's hypothetically assume that that's not an option available to you.
Okay.
On the current record, that seems like a option that does not see, let hypothetically accept that that's not an option available to you.
Okay.
Because the current record, your pleading, whatever else your motion to dismiss papers say, your pleading says that it's a Florida principal place of business. And that would suggest to me that the New York Convention does not apply. But if there's a factual dispute about that question, then it seems like a harder issue for us to resolve.
And I understand that, Your Honor. I think that, the New York Convention can apply even between U.S. citizens if there is that rational relationship that's contemplated by Section 202.
Okay, I understand that
Yeah.
argument, and I totally accept it. But assume for a minute that you have not shown a reasonable relation based on the governing law as opposed to any of the conduct. Your argument still would be, we should have the opportunity to prove that we were mistaken when we alleged that we were a Florida principal place of business.
Sure, Your Honor, if that's what the court wishes to do. I would just note that nowhere in the briefing on the enforcement issue did the appellees raise the issue of the applicability or challenge the issue of the applicability of.
The parties cannot stipulate to the application of the wrong law, right? You can't do it, right? I mean, listen, I would love it if you could. It'd make our job a whole lot easier, right? But you can't stipulate by conduct to applying the wrong law. We can't say, oh, we're just going to pretend like it applies, right? You have to actually apply the correct law.
Thank you, Your Honor. I see that my time is up, so if you have no further questions, I will,
Thank you, Ms. Cooper.
thank you.
Mr. Dasgupta?
Thank you, Chief Judge Diaz, and may it please the court. My name is Riddhi Dasgupta, and I represent the appellees in this matter. I shall address the merits of their argument. I shall
Do you
start.
represent all the appellees or just some of them?
With respect to the merits, sir, I represent all of them.
Okay.
Appellants press their New York Convention and their FAA claims. I think it's important to remember that the nub of their contention with respect to the merits is that the highly respected arbitrator Delroy Duncan, King's Counsel, Silk, in Bermuda, as they're known in Bermuda and the British Overseas Territories, as well as in the UK, he failed to disclose or recuse himself from this Bermudian arbitration, and that offended the public policy of the United States.
Well,
and was
I don't know that it's so much an objection to the failure to recuse, it's an objection to the failure to disclose, right? That's what we're talking about here. So why don't you focus on that?
Well, Your Honor, it's the failure to disclose. He didn't disclose in this matter for a variety of reasons. One is that he didn't think it was an issue to begin with, and that's the central hub and spoke of their merits argument. And the other issue is that he's a totemic figure in that community, and if he were to disclose what he perceived was a frivolous or a I don't want to use the word frivolous, but a non-issue or not a significant issue, then that would be a precedent that everybody less prominent attorneys in that community would also have to
But your
follow.
argument in some of your briefings seems to put great store on the stellar reputation of Mr. Duncan. That was his name, wasn't it?
Yes, sir.
Arbitrator. And I'm not sure that I remember very many cases where stellar reputation going to the merits of a claim has much legs. I mean, there are lots of people with stellar reputations that have fallen from grace. So what's your best argument outside of this gentleman's stellar reputation?
Well, Your Honor, I mean, the stellar reputation was a way to frame the issue, but it does go to the issue of appearance. Because when we look at whether it's in criminal law or something else, when we look at, when we try to assess whether somebody's done something, we do consider character evidence. But in terms of conduct as well, we don't think that there was, much to the contention, much to the merits of their contention, because there was no appearance of bias.
Can I ask
yes, sir.
the question? I may disagree with the chief here a little bit. Can you help me? Why does the failure to disclose matter? It seems under either Chapter 2 or Chapter 1, the concept of evident bias or some version of that requires, seems like to me under the convention, actual bias, not like a procedural error. And so
Yeah.
whether he failed to disclose or not doesn't seem to address the question that we would have, right? So if there was a procedural failure to disclose, but what was disclosed doesn't represent evident bias or some such standard under Chapter 2,
Yeah.
then why would that matter at all? I guess you accepted the chief's framing, which is generally a good place to start, but I wonder whether that framing is correct, that a mere failure to disclose could never be sufficient under the convention, that it requires actual bias, not the mere appearance of bias.
Well, I think it requires that under both FAA and the New York Convention, sir, because the New York Convention, it refers to, the language. The language there is public policy. And public policy, that's the convention has a huge pro-enforcement bias. Under public policy, it is nearly impossible. It's an insuperable standard. Nearly insuperable standard. It's an exception to the pro-enforcement side. And because the idea is that there's a certain kind of nebulousness to public policy. The phrase public policy, it has to be in Justice White's words in Commonwealth Coatings, which, by the way, I read that, as did Judge Kaufman in Moralite. That's a father-son case from the Second Circuit. he read that as that he said he thought much of Justice Black's majority opinion was dicta because it was the white concurrence that controlled. And Justice White was very clear about that. He's like, we don't want anything short of outright chicanery to call it in question. And I agree with Your Honor that evident bias also under the FAA is the same standard. If you look at, and that's in the Kaufman opinion in that case, more light, but also, I'm a textualist. I went back to the dictionary, 1925, and what does evident mean? It means manifest, it means clear, it means apparent. This miasma, penumbra's emanations of what might be bias, optics, basically, what do other people think? That doesn't cut any ice. So
Can I ask the question I talked to your colleague a little bit about? If hypothetically, Chapter 2 did not apply in this context, do you think Chapter 1, the FAA, permits compelling arbitration and affirming arbitration where the arbitration occurs in Bermuda?
yes, sir.
Okay.
So I want to go back to Judge Richardson's point about what exactly we're supposed to be looking at here, although I don't necessarily disagree with him. I mean, there is one of the arguments that your colleague on the other side is making is that there's a public policy imperative in having a arbitrator make a disclosure with respect to, potential or appearance of bias that a reasonable person on the other side would want to know about. And so the question is that part of the analysis in this case, or do we simply look at the bottom line as to whether or not the arbitrator was in fact biased?
I think that under the public policy standard, I would look at whether or not he was actually biased. I don't understand where precisely this disclosure requirement under the New York Convention public policy or evident bias, the word is bias under the FAA, where that would come from. And I think that, I was going through the Toomey through Caperton line of precedent, because I guess the test is basic notions of morality and justice. That's what for public policy. And I was going through that, and in all of those cases, the court seems to say that most of the times judicial disqualification is going to be a no-go. That judicial disqualification is judicial recusal, judicial disqualification. That's due process isn't going to control that. But in the very extreme cases, it will. So I don't see anything about disclosure in those opinions, Your Honor.
What about the University Commons case where the
That's the
court
Urbana?
set out which included some notion that disclosure might be relevant in the analysis?
I think that whether it was there or Commonwealth Coatings, it has it's a good idea sometimes to disclose, but I don't think it says that, and forgive me if I'm misreading it, that it's a must. It just says that it takes things out of the equation, it takes things out of the gray area and, puts everybody on good ice. But at the same time, and I forget which case it was, Chief Justice Rehnquist in one of the 1990s cases, he said that, look, we don't want these if we make these requirements, what that's going to encourage is for people to, is for our judges or arbitrators and others to be forced to reveal pretty much non-issues, a laundry list. I remember that phrase, laundry list of non-issues. And Justice White in Commonwealth Coatings, he said that we don't want unexpurgated business biographies and personal biographies to be revealed, to have to be revealed by arbitrators. And here we see that it would be a kind of evulsive rupture from where the Supreme Court has been, for this court or some other court to have to bravely and boldly go and say that, look, it's not the parties, it's the lawyers. And, the fact that there was a commonality or some kind of an overlap, regardless of the fact that the theories just don't work, of why the judge would be, why the judge would have had some quid pro quo or would have tried to curry favor. The fact that it's the lawyers, it just fails under the public policy test.
You don't think a reasonable party would want to know that the arbitrator who's deciding his case is being sued by one of the lawyers in a case that might spell the doom of his law firm? You don't think that would be important?
I wouldn't want to know. I hope I'm reasonable. It would seem to me to be pretty irrelevant. It's the lawyers. It's a small legal community. There are only 544 lawyers at the Bermudan bar. I checked last night, and there have been 24 lawyers added since we filed our brief. And arbitrator Duncan, he's at the pinnacle of the profession. I don't mean to again put great store in his reputation, but he's at the pinnacle of the profession. They needed to find, you saw in the 71-page final award, it's an involved opinion. They deal with a lot of things about Bermudan law, English law, the law lords, now the UK Supreme Court, all those issues, and they needed to find somebody who would be good enough, strong enough, robust enough, and erudite enough to render an opinion like that. And who's suing whom, why, and the fact that it's lawyers. If it were parties, that would be a slightly different question, perhaps. But this is an entirely different fox hunt altogether.
So let me ask you a slightly different question. As I understand what happened in this case, you correct me if I'm wrong, your clients would have initially filed in the district court and seeking an order to arbitrate, which they got. And then they came back and filed an application to enforce the arbitration award by the arbitrator in Bermuda. And in your application, you said this is the court's authority to act is under the New York Convention, Section 2, correct? Yes?
Yes.
Okay. So if we were to determine for whatever reason that was an error, there was no reasonable relation, for instance, to a foreign country, what would happen at that circumstance? There's been some discussion about whether the FAA could apply, but as I understand how this transpired in the district court, that's never an argument that you made. The only argument about it was by opposing counsel as a defensive argument. So if that were the case, how would you proceed under the FAA to confirm your award without sending it back to the district court?
Your Honor, that is a procedural and jurisdictional matter that my colleague would be better equipped to answer than I. But if Your Honor would like, we are happy to offer further briefing on that issue.
Okay. Well, let's see what opposing counsel has to say.
Anything else? Thank you very much.
Thank you, Your Honor. I believe the court understands my position with respect to the jurisdictional issues. Happy to answer any questions that you all may have on that set of issues.
What's the base, to go to the chief's questions on the merits, assuming we got there somehow, what's the best case or thing that I should look at to understand that there's like a public policy exception under Chapter 2 for mere disclosure of a fact that itself does not create evident bias? Right, so, I mean, because if it itself creates evident bias, then we just are on the merits. But where would I look to find some suggestion that there's like a disclosure, a mere disclosure piece under Chapter 2?
Okay, so Chapter 2 incorporates the New York Convention, which provides 7 express grounds of which you can challenge it, one of which is
public policy.
Right. And so in Commonwealth Codings, the Supreme Court said that, announced the well-defined and dominant U.S. policy that arbitrators must disclose to the parties any dealings or relationship that might create an impression of possible bias. And subsequent federal courts have, or federal cases have held that although Commonwealth Codings was decided in the context of an evident partiality standard, its announcement of U.S. policy is nevertheless applicable to Article 4 of the New York Convention, which is the public policy defense. And so those cases include Transmarine Seaways Corporation of Monrovia v. Mark Rich and Company, AG, 480 F Federal Supplement 352. It's a Southern District case from 1979. And similarly, I think that we've kind of been conflating the public policy defense with the evident partiality defense. And I think those are separate issues in this case. I don't think those standards are the same.
So you think that the Chapter 2 standard of public policy is actually broader than the Chapter 1 evident bias standard?
I believe so, Your Honor.
You
Yes, and I
think
think
that
the cases demonstrate that.
The public policy is actually like more protective?
I think so, or at least has less, it has at least has less case law kind of describing the bounds of it. It's a little bit more of a amorphous kind of topic. There's not the A&R Cole factors or something like that for the public policy defense, whereas there is for the evident partiality defense. So that's where I think the public policy defense, how it frames the issue is the Commonwealth Coatings and then it's
Well,
Commonwealth
Commonwealth
Coatings.
Coatings was not a Chapter 2 case, was it?
It was not.
Okay.
And that's why the subsequent cases like Transmarine Seaway cases talk about how while Commonwealth Coatings was a domestic arbitration award under Article 1, it's equally applicable to claims for non-enforcement under Article 5.
Well, then you
of
seem
the
to be,
York Convention.
so my question then is, are you suggesting that there are different standards under Chapter 1 than Chapter 2 with respect to disclosure, or does it apply across the board?
I think there are different standards. I think that there's the public policy
Why
standard.
would Congress create different standards?
Because one deals with foreign arbitration awards under the New York Convention, which is kind of this whole body of law, and the other deals with domestic awards under Section 1 of the FAA.
So would evident bias in effect, under your view, be subsumed within the public policy argument?
I think they're very related. I think that they are overlapping circles, but not exactly the same, because the cases discussing public policy haven't articulated such, the kind of the four-factor tests like
Give us
A&R Cole.
your best, very pithy, direct, why is there a problem here with the failure to disclose this relationship with the lawyers when it's not parties? Why is that an overwhelming show of either evident bias or a violation of public policy?
It's because, Your Honor, that a reasonable observer could, Chief Judge Gia said, that a reasonable observer would want to know that the person deciding the facts and the law in this matter is being sued by a former client that is represented by the same lawyers that are representing the party to the arbitration. And like the 11th Circuit discussed in University Commons Urbania.
Because you think that there would be the temptation to throw them a bone, so to speak.
Sure, I think that they're under the, similar to the Caperton case, I think that under, a realistic appraisal of human psychology and human weakness, that arbitrator Duncan, subconsciously or not, would use whatever influence he could to, in an attempt to influence the counsel
So
who is.
what would happen if you thought it was equally feasible that he would take the position that I'm going to show these guys how tough I am, so that they're going to know they're in for a real battle. So I'm not going to be helpful to them at all.
I think that is possible. I think it's less likely, given that arbitrator Duncan, would presumably not want to antagonize the very lawyers who are spearheading the claims against his firm.
All right, thank you very much, Mr. Ford. Thank very much the lawyers for their argument in this case. We'll come down and greet you and move on to our final case. final case this morning is 23-1722 McDougal versus Garland. Ms. Mayor Salins.
Good morning, Your Honors, and may it please the court, Amy Mayer Salins for petitioner Marlon McDougal. This petition asks this court to decide only two questions. First, whether the Board of Immigration Appeals was wrong to conclude that the harm that Mr. McDougal fears, including government actors sodomizing people with police batons or setting a young man's genitals on fire, whether that kind of harm does not meet the legal definition of torture because the government actors lack the required specific intent. And second, whether the agency erred in ignoring evidence relevant to the possibility of torture. With respect to specific intent, the BIA erred in two ways. First, it erred by requiring the petitioner to show that the national government of Guyana acquiesces to the actions of low-level government officials. The CAT, of course, does require a connection between the torture and the government. But per 8 CFR 1208.18A1, that connection need only be shown in one of two ways, not both. The petitioner can either show that the torturers are private actors and the government acquiesces to their behavior, or that the torturers are themselves government actors. Here, the BIA never analyzed the specific intent of the officials engaged in torture. Instead, it just analyzed whether the national government was attempting to address the problem, as you can see on page 5 of the joint appendix, despite the fact that Mr. McDougal had raised that government actors themselves would be engaged in torture.
So this is a case where your client didn't allege, no evidence that he had been previously tortured, right?
That's correct.
So why isn't the ability of the government or its initiatives to reduce the probability that he would be tortured if returned to his home country relevant on this issue?
Your Honor, I think it's relevant to the likelihood analysis, but that's an analysis that the BIA didn't engage in. The BIA simply found that whatever the likelihood of this harm occurring, it doesn't meet the definition of torture. And so because it doesn't meet that definition, it didn't go on to step 2 of deciding how likely is it that he would actually face torture. And we would ask that on remand, the agency take up that likelihood analysis and determine how effective are these government programs, how effective is this new legislation in addressing these issues. But what the BIA did here is hang its hat on specific intent. And in that sense, it was problematic because it essentially immunized the extrajudicial actions of low-level officials from the CAT's scope. In matter of OFAS, the Attorney General said that that's wrong because it resurrects the now defunct rogue official test. And what the BIA here should have done instead was separately analyze the intent of the torturers and then their connection to the government.
This is one thing I was confused about in your briefing. What torturers are they supposed to be analyzing?
They should be looking at the intent of the individuals who are engaged in the actions, the heinous actions like sodomizing people with a police baton.
So you have these actions. They don't have any relationship to the alien in this case, correct?
Well, we would argue they do relate to
All right, so how?
because Mr. McDougal has the same risk factors as the people that are detailed in the evidence here. He is also a person with physical disabilities, mental health disabilities, a Black Guyanese citizen, a deportee with criminal records. So the evidence here pointed to those vulnerabilities and people with those same vulnerabilities who faced horrific, heinous acts when they returned to Guyana. And so in looking at those vulnerabilities, that's what the agency should be thinking about. Is somebody in Mr. McDougal's position likely to face torture? And here they should have looked at the specific intent of the torturers and then their government connection. The second way in which the BIA...
So how would they go about doing that?
I'm sorry, Your Honor?
How would they go about doing that? I mean, did you proffer some evidence or something?
With respect to specific intent on the individual, I think that this court has set an oxygen that we use the general criminal law understanding of specific intent. And so in looking at the actions of specific torturers, you want to look at whether
they had the intent to commit the act as well as achieve its desired result. And so here, I think there is a big difference between someone who acts recklessly and somebody who sodomizes someone with a police baton. I mean, that seems to be a quintessential criminal act that would meet the basic definition of specific intent.
And who has the burden on intent?
The petitioner.
Okay. And so you say you satisfied the burden by the evidence in the record describing these various admittedly heinous acts, and even though you don't have any individual official saying, yeah, I did this with the intent to torture, that essentially the facts and the acts speak for themselves.
Yeah, I think that you can infer intent, and this court has held as much oxygen. I think the general rule in criminal law is that an inference of intent by the fact finder is okay. But here the BIA didn't even go into that inference of intent. It simply said that you can't show intent here because first, the national government isn't acquiescing to the actions of these low-level officials. But then secondly, the BIA said that the BIA concluded that inadequate training defeats the specific intent of the torturer. And that's problematic for two reasons. First, it's problematic because an inadequately trained officer still acts under color of law. In matter of OFAS, the Attorney General said that under color of law from our civil rights jurisprudence is the same thing as official capacity in the CAT context. And so civil rights jurisprudence is instructive. And this court's jurisprudence, as well as the Supreme Court's precedent, has been quite clear that even where officers overstep their authority or abuse their authority, they still act under color of law. Lack of training isn't the relevant analysis. If you take, for example, this court's case in Worth versus Searles, which took up the case of a highway patrolman who had crossed state lines to arrest a suspect, this court rightly didn't analyze whether the officer who effectuated that arrest needed more training on extradition procedures. He probably did. But instead, it focused on the rights of the defendant, the rights of the suspect. Because 1983, like the CAT, is supposed to protect people from government abuses. In a more gruesome example, the Supreme Court in Screws took up the case of two police officers and a sheriff who arrested a young black man on the pretense that he had stolen a tire. They handcuffed the man and beat him to death outside of a courthouse. And there, the Supreme Court said that those officers acted under color of law. They were officers who made an arrest. They allegedly beat the man to keep him from escaping, the suspect from escaping, and to protect themselves as officers. Those officers obviously overstepped their authority and abused their authority, but they still acted under color of law. In matter of JGR, the agency said that.
So, but in all those cases, you've got the ability to take the evidence of the individuals involved and including the law enforcement officers. And maybe I'm just not picking up on the threads of your argument here, but I'm still not sure exactly how the IJ or the BIA was supposed to determine the specific intent of these completed actions in the past, because other than the fact of the actions, there's no evidence, is there?
Well, I think that the agency, the fact finder, is permitted to make inferences about the specific intent of the torture, just like they make inferences on what the torturer is thinking in all, or what the persecutor is thinking in all kinds of other contexts.
Let's just take the case of the person who was sodomized there. What inference are they supposed to draw from that relates to your client's case?
I think they can draw that officer was not acting negligently or recklessly. No one accidentally sodomizes someone. That officer clearly was acting purposely. And so if you know that there are officers who act purposely in that manner against people with the same vulnerabilities that my client has, that is strong evidence
And so
that this
there's
person.
evidence in the record that shows that your client matches up with whoever this victim was?
Yes, Your Honor. The record shows
multiple instances of people who have similar vulnerabilities to my client. So, for example, the, excuse me, the disproportionate targeting of black men, we have evidence highlighting that on page 308 of the joint appendix. On page 506, there's a uniformed police officer tackling a black man to the ground and using handcuffs to beat him repeatedly. On page 508.
But why, help me understand why. I understand, you know, we could look at any city in America, right? And so we can find examples. The question is, like, how do we know the specific intent in any one of those examples that you want to give, you know, was to torture on account of being black or being disabled or being whatever, right? I mean, I certainly understand that the examples you give are examples of misconduct, and bracket for a minute whether a handful of misconduct shows a likelihood of torture. But why do we even know that those were like the type of specific intent that matters for our purposes?
Well, Your Honor, there's no nexus requirement under the CAT, so it doesn't have to be on account of race or something like that. Rather, those vulnerabilities go to whether my client in particular is likely to experience the same type of harm. But specific intent is just about whether the actor intends the consequences of his actions, or whether instead it's a lower mens rea of recklessness or negligence. What we're talking about here is not reckless behavior, it's not negligent, it's not even gross negligence. There were examples in the record of things that are criminal because they meet that specific, that higher mens rea standard.
So just to, and I hate to beat this dead horse, but I thought correct me if I'm wrong, your argument is that the BIA and the IJ never engaged with this issue of intent. They simply looked to the government efforts to stop this violence and said that that negated intent, and that's not the right analysis under your view.
That's correct that's not the right analysis. They did engage with this idea of intent, but in so doing, I think they erred. Because first, they confused the mens rea requirement and which actor they were supposed to be looking at. And then with regard to the specific actors involved, they concluded that inadequate training defeats specific intent of the torturer. And that's problematic under the civil rights framework. It's also problematic because ignorance of the law is no defense to a specific intent crime.
So is there any way that we could affirm nonetheless or deny the petition by taking Judge Richardson's point that based on this record evidence, in the absence of any direct evidence of the officer's intent, there isn't enough to go?
Well, even if this court disagrees with me on specific intent, it still ought to remand this case to the agency because the BIA did not address evidence of increased risk for Black Guyanese people, people with physical disabilities, deportees, or people with criminal records. And while the government says that this is just an example of lack of clarity, the BIA only discusses risk due to mental illness and has one line in its decision alluding to the general population's treatment of criminals on page 6 of the joint appendix. But there's nothing on police or state actors' treatment of criminals and no reference whatsoever to the risk for Black people, deported people.
I'm sorry,
people
wait,
with
help me.
physical-
So you think you have a standalone torture of criminals argument, independent? I understood your criminal argument to be dependent upon your mental illness argument, that because he's mentally ill, he is then going to go commit criminal acts and therefore get treated as a criminal because he's committed criminal acts.
No, Your Honor, we would note that he is at increased risk for torture based on stigma against people with criminal records as well. And under Kerr and Rodriguez-Arias, the agency
I know, but
should-
that's a separate argument. Go back to the idea, are you making a separate argument about him committing criminal acts and then being mistreated?
I think it's both, Your Honor. He could have a mental health crisis that causes him to engage in criminal acts, but he also
And is that
faces-
sufficient? I guess the question is it the fact that he could commit criminal acts and then be punished for those criminal acts?
No, I
Is
don't.
that-
I don't think that that is sufficient in and of itself. What we're saying is that he is at increased risk of torture
both because he could decompensate and have a mental health crisis that causes that, but also because people with criminal records are at greater risk of torture simply because of the stigma and the way that police and other government actors treat people like Mr. McDougal.
And what, just so I can find it, what is the evidence that you offered on that specific point? The fact that he committed crimes in the United States will make him likely to be tortured in his home country?
Yeah, so on page 589 of the joint appendix, you'll see the law about deportees with criminal records being subject to monitoring by the police, and then page 565, 570 through 71, 568 all have information about deportees with criminal records being at increased risk. And so
But I don't understand that to be any, so yes, they're monitored, like, perhaps that's like a really good idea, right? If we had criminals coming into our country, I think it'd be great for us to monitor them too. The question is, why does that, like, what does that evidence tell us about that he is likely to be tortured?
I think it does go to likelihood. Where police officers are engaging these kinds of heinous acts, we need to know how likely is it that he's going to be in contact with police? How likely is it that police are going to engage in acts that, but frankly, this court need not decide that because the BIA didn't decide it. The BIA didn't do the analysis of how likely is he to face torture. And it's something that the BIA should certainly do on remand, but all the BIA did here is look at whether the government actors had the specific intent to torture him. And in doing that analysis, they erred in their understanding of the legal requirements for specific intent. And so respectfully, Your Honor, we would ask that the court vacate the BIA's decision and remand for the agency to do that analysis in the first instance.
Thank you, counsel.
Thank you.
May it please the court. Jacqueline Hagner on behalf of the Attorney General. The record here does not compel the conclusion that the government of Guyana specifically intends to torture petitioner, that the government would acquiesce to his torture, or that he would face a likelihood of torture upon return to Guyana. I'll begin with the issue of specific intent. In fact, Judge Agee, I'd like to turn to your question for petitioner, which was how do you show specific intent? The answer to that question is actually what this court discussed in Oxygen. In Oxygen, we were dealing with deplorable prison conditions in Haiti for criminal deportees. And ultimately, the court in that case said, we just don't have evidence of specific intent here. What we have is that essentially we have all these criminal deportees, and it's just unfortunate that these prison conditions exist, but the evidence the record is just void of any evidence that the Haitian government specifically intends to torture these deportees. However,
but that's different than the evidence that appears to be in this record of specific acts that seem to be just really virulently violent and heinous that a reasonable person might infer that the officers in question intended to torture somebody. I mean, and so the question is, did the IJ and BIA conduct the correct legal analysis? And you might win in the end, I suppose, with the argument that even if these incidences occurred, that the government of Guyana has now taken steps that would make it less than likely that this particular petitioner would be tortured. But that's a separate issue from whether or not the IJ and the BIA engaged with the correct legal analysis on the front end.
yes, Your Honor. I have two answers to your point there. I think that it's important to look at, if I may go back to Oxygen, what this court did was it looked at the Ninth Circuit's decision in Redor. In Redor, there was evidence from an expert who testified about specific intent of the Haitian government. That expert said that there was a national policy in Haiti to torture criminal deportees. And the expert explained why there was that national policy and what evidence showed that. That type of evidence, that nature of evidence, is absolutely absent from this record. And so inference, as you said, Your Honor, Judge Diaz, that we have these brutal acts by police in the records. These brutal acts maybe you could infer that there was an intent to torture, but I would submit that an inference does not compel the conclusion, because
So where does the BIA and IJ actually do that analysis, other than to say, as your colleague on the other side says, that, well, the government has taken all these steps to ameliorate the violence, so therefore there's no intent?
Right, Your Honor, I think that's a great question. It would be on page 4 of the board decision, which is page 6 of joint appendix. In the first full paragraph, this is where the board says, "We affirm the immigration judge's finding that the respondent did not establish a sufficient likelihood that he will be tortured," in quotation marks, "by government officials." So what we're doing here, what the board is saying here, is that the definition of torture, that there's, what petitioner claims to happen, is speculative. And in addition to that, the board cites to this court's decision in Singh, which Singh stands for the proposition that the mere existence of human rights violations in the record is not sufficient to show a likelihood of torture. In addition to that, the board also cited this court's decision in Ibarra-Chavez. In Ibarra-Chavez, that case stands for the proposition that just because a particular individual has certain characteristics that might make him susceptible to torture does not itself establish a sufficient likelihood of torture. So to kind of sum up what the board did here is it basically said that the government of Guyana does not specifically intend to torture. Moreover, all of these incidents of harm that petitioner manages to find newspaper articles of isolated incidents of police brutality are not particularized to petitioner. I think petitioner seems to suggest that he has the same characteristics as some of these victims in these newspaper articles, and because of that, he's going to be just like them. That is certainly just does not rise to the level of compelling the conclusion that he will indeed suffer torture.
So can I ask, just to be clear, if the finding in this case by the board had been, and you read something that suggests it might not be, that notwithstanding this record evidence of these horrific incidences of torture, the BIA finds the government of Guyana does not acquiesce in that torture, therefore there's no intent. That's a mistake, right?
I would tend to agree with you, Your Honor. I think that it's confusing or conflating two issues. I think the best way, but it's two different elements, right? So government acquiescence is one aspect of the claim, but there's also specific intent. Basically, the board did not get to the issue of government acquiescence. I understand that the immigration judge did, but that was not expressly adopted by the board here. The board rested its decision on specific intent and lack of a sufficient likelihood of torture. So government acquiescence, is, to be clear, is simply not before the court in regards to harm at the hands of government actors. It is before the court in terms of harm at the hands of other individuals like detainees and the public at large. But at the hands of government actors, government acquiescence is simply just not relevant. That issue is just not informed by the board.
And that's because the evidence with respect to government actors based on these prior incidents is just too speculative?
Correct. Essentially, it's not torture. Without specific intent, you simply don't have that requisite element of torture, which, again, this court's decision, Oxygen, sufficiently explains that, and as the board did here, refers significantly to the board's decision in matter of JE, which explains why specific intent is required for torture. I would like to make clear, I think that we did just make clear, but just be ultimately clear here, that the board did hold that there is no likelihood of torture at the hands of government actors. And just to reiterate, the reason for that is the board's citations to this court's decisions in Singh, Ibarra-Chavez, and quite frankly, it's the last sentence of the board's decision, is that petitioner has not met his burden to establish a likelihood of future torture in Guyana by or with the acquiescence of the government. And in addition to that, on page 4 of the board decision, the first full paragraph also makes a similar decision, affirming the immigration judge's decision on that matter. Also, I would like to address petitioner's argument that the board ignored, or I should say the agency ignored evidence regarding harm to individuals who are criminals or have dark skin or with disabilities. That is also simply not true. Here, the board on page 4 of the decision states that the immigration judge clearly did not err in finding that the government of Guyana does not intend to torture its citizens. So in finding no clear error of the immigration judge's decision on that matter, that it is express affirmation or adoption of the immigration judge's decision on that issue, you look at the immigration judge's decision, and the immigration judge's decision, you see, is pretty thorough in discussing the evidence that was presented, and the immigration judge's decision expressly mentions those grounds on which petitioner now claims the agency ignored. So those grounds are expressly mentioned in the immigration judge's decision. Moreover, on page 10 of the immigration judge's decision, the immigration judge then aggregates all claimed sources of harm and says that it's just too speculative, citing to matter of JFF for the proposition that we have a series of suppositions here, each one of which petitioner has not established that is more likely than not to happen. And for that reason, his claim is just too speculative.
So, your view is that in certain instances, the board independently analyze certain issues, and therefore we rely solely on the board, but in certain areas, we can rely on both.
Correct, Your Honor.
And that's even though there's no indication that the board expressly adopted the IJ's opinion, right? We kind of have to infer that, or?
On that last matter, Your Honor, I disagree, and I'll explain to you why. So I will agree that the agency decisions here are confusing in terms of what the board affirms with the immigration judge. However, if you were to go through the board's decision line by line, you will see that it is replete with findings that are the words affirming, agreeing, finding no clear error, and then citing to pages of the IJ's decision that it affirms, agrees, or finds no clear error.
I mean, it's hard to think about anything other, if you say there's no clear error with the judge's finding, if that's your conclusion, how would, I guess, that seems to naturally incorporate the conclusion, right? If you're not saying that it's right, you're not necessarily saying that you adopt that conclusion. You're saying there's no clear error with that conclusion. That would seem to necessarily adopt it, wouldn't it?
Yes, Your Honor, it would necessarily incorporate, which is...
Right, incorporate, I mean,
Right.
is the better word.
Right, and that word incorporate is the exact word that was used by this court in Sierra Rivera, which granted is an unpublished decision, but the reason respondent cites that case in its brief is because it addresses the specific circumstances of the board's decision that are similar to this case, which is when the board says clear error, or we find no clear error, that means that it incorporates the IJ's decision. Does that make sense?
Because otherwise, like when we say there's no clear error with a district court, the only way you can understand that is by virtue of the district court's ruling.
Precisely, Your Honor, I agree with you. And again, to the extent that petitioner faults respondent for citing to an unpublished decision, this court has held similarly in published decisions. Most recently, in February of this year in Santana, this court held that when you expressly reference the immigration judge's decision on an issue, the board's decision then incorporates the immigration judge's reasoning on that issue. So unfortunately, Judge Diaz, what that means is that going through the board's decision, it is necessary to look at what and when the board incorporates the IJ's decision, because it's not on every issue that the immigration judge ruled on, if that helps. I could summarize and say that ultimately what you have before the court, as affirmed by the board, is specific intent at the hands of government actors does not exist, nor does the likelihood of future torture. That does not exist at the hands of government actors. In regards to harm at the hands of other individuals, detainees, or the public at large, what the board affirmed there was no government acquiescence and that there's no likelihood of torture. That it would be a summary of what the board affirmed from the immigration judge's decision. If there are no further questions, I can conclude.
Thank you.
I will conclude by stating that petitioner is an aggravated felon. He was convicted of carjacking and burglary and sentenced to a total of 9 years of confinement. This is something that petitioner does not dispute, and that is why he is only eligible for deferral removal under the Convention Against Torture. However, his claim lacks merit for the reasons we just discussed and the reasons in the agency's decision, and the court should deny the petition for review. Thank you.
Thank you, Ms. Hagner.
Your Honors, I'd like to address a couple points that my colleague made. First, on the question of how do you show specific intent, she cites to Oxygen. In Oxygen, this court gave an example of how one can infer specific intent. The example given was when somebody is kidnapped and then beaten severely. This case also has examples just like that, and this court should follow its own precedent in inferring specific intent of the actors involved in torture. Additionally, I wanted to address a little bit about the immigration judge's decision here. First, my colleague notes that the immigration judge allegedly analyzed other sources of vulnerability like physical disability, race, etc. That simply isn't true. If you look at the IJ's decision, the analysis section begins on page 106 of the joint appendix. In the analysis section, there is no mention whatsoever of physical disability, of race. Instead, although the immigration judge does list all of the evidence at the beginning of her decision, there's no indication that she actually analyzed those vulnerabilities. And so even if this court, in my opinion, wrongly looks at the immigration judge's decision, it's the same problem with ignoring evidence of additional vulnerabilities. With respect to whether the immigration judge's decision should be the subject of review here, it should not. It cannot be that whenever the BIA employs the clear error standard, which is the standard it is required by regulation to employ when reviewing factual findings, that somehow counts as adoption or incorporation. Adoption or incorporation is like a copy-paste.
What do you do with Santana, where they're, like, you seem to suggest, in the briefing at least, that there's like a magic words test, right? That if the BIA doesn't use the magic word adopt or incorporate, that it doesn't count. But it doesn't, at least my recollection of Santana is that the court there was like applying the standard of review, and sort of that the court found sufficiently adopted that they reviewed both decisions.
Yeah, I will grant that this court's precedent on this is a little bit mixed. But this court in Martinez and in Wambura and Cabrera Vasquez has explained why it's so important to look only at the BIA's decision. And now the BIA can incorporate parts of the IJ's decision if it so chooses. But to do that, it has to be explicit about that, because otherwise there's a jurisdictional problem here. And so the BIA does do that sometimes. There's matter of Bourbano affirmances. There's times when the BIA explicitly says, we adopt the IJ's decision on X, Y, or Z. But that's simply not what happened here. Instead, just like when this court...
You think the standard is that absent magic words, we can only review the BIA? Absent the word, we hereby adopt and incorporate. Absent those words, we can only look to the BIA. And that just doesn't seem consistent with what we've done.
I don't think it has to be magic words, but I do think it has to be clear that that is what the BIA is doing, and it is not simply doing its own analysis like it did here. Here it has 5 paragraphs on specific intent, where the IJ had just 1. And I see that I'm over my time.
Can I ask you one more question?
Of course.
At the very beginning of your argument in rebuttal, you said that this court could infer intent based on this record, but that's a sufficiency argument, and your colleague on the other side says that the BIA rejected that. And so if that's true, why are we in a position to overturn that? At the very beginning of your argument, you said that we're not in sufficiency land, we're in legal error land. So which one is it?
I think you're in legal error land, Your Honor. I think that the board did the wrong legal analysis here, but to be responsive to your questioning from this court about how intent could be inferred, that's what the BIA should have done, what the IJ should have done, but didn't. Instead, what they did was employ the wrong legal analysis here in finding that where the government doesn't acquiesce to the actions of low-level officials, or where those officials lack the training needed to know better, that there can be no specific intent. And that is legally wrong. Thank you, Your Honor.
Thank you. Thank you both very much for your arguments. We'll come down and greet you and adjourn court for the day.